Hi everyone, welcome to live virtual classes of Board of Studies ICAI. This is a class which we are having under the topic General Clauses Act in paper 2 Corporate and Other Laws for CA intermediate students. This is a continuation class. We have discussed about the General Clauses Act in our previous session, and this is the second session, and we will be covering the General Clauses Act completely today. That is our objective. I gave you a background. If we have a quick recap of what we discussed in our previous class, I gave you a background and objective of this session for you people, why we are reading General Clauses Act. And as I explained you in my previous session, that General Clauses Act are meant for supporting an interpretation because words have different meanings and we need to understand these words, and word as a medium needs to be understood very clearly by people. And to lessen the confusion, to reduce the repetitions, we have this particular legislation. And whenever you are in confusion in your particular interpretation of a law, you can always lend help from the General Clauses Act. This is what we discussed. One important point we also discussed is that General Clauses Act is applicable to the central legislations only and not to the state legislations. And for state legislations, there are different General Clauses Act. As for example, I have given you the Karnataka General Clauses Act 1899. Similarly, we took another example of General Clauses Act of West Bengal. I gave you an example in my previous session. You can refer to that particular session. There are learning outcomes, and we have achieved already the learning outcomes, the 4 learning outcomes, partially the 4th one, that is explaining the purpose of General Clauses Act. So after the session, you should be able to do it. And I'm sure by now you should be able to explain what is the purpose of General Clauses Act. You should have some basic understanding of the legislation, how legislation is read, what are the major portions of a legislation. This also we discussed in our previous session. And I'm sure by now you have an understanding about the legislation, that is beginning from short title, then preamble, then definition section, then substantive clauses, repeal and savings clause, all these things which we had discussed in our previous session. Knowing general definitions under the Act. So we, if you remember, we categorized different definitions into different buckets, and we tried to understand all those definitions. And the objective of these definitions are basically to provide clarity in different statutes about different meanings of the words, because a word in law may have different connotation and meaning, and which needs clarity. An example we gave was the Income Tax Act resident definition of resident, you see, and the definition of resident in FEMA is a bit different. I gave you another example of definition of control in competition law and definition of control in SEBI law. These are different definitions. And then we actually started with the chapter on identifying general rules of construction. In fact, we did with the repeal clauses. What do you mean by repeal of legislation? What happens after a legislation gets repealed to the actions which have already been taken or to the actions which are contemplated? So that thing we have already discussed. We will repeat that also in our next slide. In today's session, we will all specifically focus on 2 things, that is explaining the power as to orders, rules, and etc., which are made under enactments. And also we will gain knowledge about other miscellaneous provision under the General Clauses Act. Now to move further in terms of the detailing of the sections, we have dealt with till section 8, and the remaining sections which we are going to talk about today in our today's lecture. Now to move further, before I go ahead with this, I would like to pick up some questions if you have from our previous session. If you have any questions which you feel is, boggling your mind, or you read the literature and after reading the literature, something which comes to your mind which you want an address, you can ask me now so that I can address them and you have clarity on sections starting from preliminary to section 8. If there are any questions, you can put it in the chat box, as well as I am tracking your admin panel where you have any other question. Okay. So I find that on the admin panel, there are no questions. If I see here, I have Mr. Dash, who is saying good evening, Mr. Dash, and the remaining students who are at the chat box. If you have any question, you can ask. If you don't have question, let me proceed. You will have plenty of time to ask me questions while I take different breaks after the slides. So at that point in time, you can ask me questions. Let me proceed further and reiterate section 8. So section 8 basically goes like this, and it says construction of references to repealed enactments. So basically, this section is giving you a background as to what you will do wherever there is a repeal provision in a law. So if there is a repeal provision in a law, how to deal with that situation is what is dealt with in section 8. So it says, where this act or any central act or regulation made after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, then references in any other enactment or in any instrument to the provisions so repealed shall, unless a different intention appears, be construed as references to the provision so reenacted, right? So this is what is the provision. And if you look at this particular provision, it is basically trying to say that if there is something which is repealed and after the repeal, a new law is enacted, so you will be referring to the new law rather than going back to the older law. So this is what it is trying to tell. I will give you one more example. It will become more clearer to you. So where before the 15th day of August 1947, an Act of Parliament of the United Kingdom repealed and reenacted with or without modification. So this particular provision, subclause 2, may not be very much applicable right now in the present context for a simple reason that now we have moved, we have already more than 75 years of independence. And this provision was a transition provision at that point in time when we got independence and General Clauses Act interpretation was extended to Indian legislations. At that point in time, there were certain legislations from British India, from United Kingdom, which were applicable to the British India, and those things got over a period got interpreted. And I don't think that now there will be any case which is so long pending that there is a requirement of this interpretation. So just leave it. I think there is no requirement of too much of an attention on this. Let us have a look at on the example. So in section 8, the example is given in your booklet as well. And it says in section 115 JB of the Income Tax Act 1961 for calculation of book profits, the Companies Act 1956 are required to be referred. With the advent of Companies Act 2013, the corresponding change has not been made in section 115 JB of the Income Tax Act. So when you refer to section 8 of the General Clauses Act, book profits to be calculated under section 115 JB of the Income Tax will be as per the Companies Act 2013 rather than Companies Act 1956. So there is no requirement that there should be express amendment in the Income Tax Act with reference to Companies Act 1956. Even because 1956 Act is repealed, now new law has come up. So equivalent provision you will read from the new law. This is what it is trying to tell you, right? I noticed someone of you have raised the hand. Let us keep your hands down. We will give you an opportunity. At that point in time, you can open your mic and then speak when we discuss this particular thing. Okay, hold on your questions. You can note it down right now, and then we will interact at the specific junctures. Now let us move ahead, and this particular provision gives you clarity. So there can be different other examples also in this which we can look at it. Like say, for example, there is an example which I find in one book is relating to Land Acquisition Act. So you all are aware there was a Land Acquisition Act in 1894 and which was repealed by way of 2013 legislation, which is a very long name. That is Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. Then any references to Land Acquisition Act in any of the legislations would now be reference to 2013 Act. Now, can there be an exception to this? Yes, there can be exception to this if the law specifically mentions that no, your reference is only to that particular provision, or it specifically incorporates that provision. Then that will be discussed in a different way. So this is how you need to interpret this particular provision. Now let me talk about another section and move ahead on this particular repeal of laws. But I just wanted to show you that how repeal and amending act are passed. So this is an example of repeal and amending act, and you can see here this is of 2023, and it says the enactments specified in first schedule and second schedule are hereby repealed. So in a year there are repealing and amending act passed, and all laws relate which has to be repealed gets repealed by this way. For your information, this government had actually put a lot of focus on repealing the obsolete laws. More than, I think more than 1500 or 2000 laws are being repealed by the government, because those laws were on statute book, but they were not being used or they had become obsolete. So government took a decision to repeal those particular laws, and hence this repeal and amending act repeals those particular laws. Now, here it is interesting to note that repeal and amending acts actually repeals even the various amending acts. I will give you an example. Like, for example, we are having this, Insolvency and Bankruptcy Code Amendment Act. So if you will see, Insolvency and Bankruptcy Code Amendment has been done several times, right? So you will find that there are many amendments to Insolvency and Bankruptcy Code. Because of the nature of the legislation, there were a number of changes which were required. And due to that, the law has been amended many times. So all those amending acts, if you see, the changes have been brought. So whenever a new amending act comes up, it actually incorporates the older provision also into it. Hence, the first amendment act or second amendment act after the third amendment act comes up becomes useless, right? Because those changes have already been incorporated in the new law. So it basically says that if you are having a repeal and amending act, then the repealed provisions in a particular act does not go away. Like, so it is incorporated in the new law. So hence it does not affect the changes brought by these amending acts in the IBC. So this is a very clarity which is given. In terms of section 8, I will like to give you another example. Like, so it says basically section 8 in a nutshell says that when a later statute incorporates by reference the provisions of earlier statute, a repeal or amendment of the earlier statutes do not affect the later statute or provisions incorporated therein, right? So let us take an example. So there was a repeal and replacement of the Mines Act 1952, and the reference to the definition of coal mine as defined in Mines Act 1923 in Coal Mines Provident Fund Act 1948 was construed as referring to definition of coal mine in Mines Act 1952. Though even if Mines Act was repealed and it replaced by coal mine, Mines Act 1923 was repealed and Mines Act 1952 came up. So even if Mines Act 1923 was repealed, the definition of which was provided in the Mines Act 1923 was taken forward in interpreting the definition of coal mine. That this is basically a case, State of Bihar versus S.K. Roy, in which this interpretation was brought forward. So I think by now you have understood the context of repeal. So whenever there is a repeal of a law, everything doesn't go away. The things which have been done, and that is there, which you find in section 6, particularly clause A to D, we have taken the example yesterday. So those situations are saved. Those situations are, if there is a right which is accrued, if there is a liability which has arisen under the previous law, that continues. So this is what is the object of repealing and amending act and the provision relating to repeals. There is now I can take questions on any of this repeal of laws. If you have any questions, any one of you. Yes. You can use the chat box, and if admin is there, they can permit even speaking by candidates. I don't mind. Yeah. If you have a comment or a question at this juncture, any one of you. Yes. Yes. Can we permit Mr. Anil for speaking? Yes, Anil, you want to speak? Go ahead.
Good evening, sir. I'm audible.
Yes, yes. You are audible. Be a bit louder.
Sir,
Yeah.
I'm confused. The difference between repeal and amendment are both the same.
Repeal and amendment, right?
Yeah, sir.
Okay. So repeal is actually removing. Okay. Amendment is change. So say, for example, when I say repeal, repeal is completely removing that particular law from the statute book. So, that law no more exists. Once a law is repealed, then that means it is no more existent. When you say amendment, it is a part of that particular provision gets amended. So the law is very much there, and then a part of it gets, amended or changed. That is what is the difference between repeal and amendment, right?
Okay, sir. Thank you.
Yes. So when we say repeal, repeal is en bloc. So we are basically repealing the complete thing. And when we say amendment, it is always a part of it gets amended. A part of the section or maybe part of the chapter, that is called amendment. Right?
Okay, sir. Thank you so
Yes.
much.
Any other question? Any one of you? Okay, I think there is one more candidate who raised the hand. If you have any question, you can ask. If you don't have question, I will proceed further, and then you can, ask later. Now let me talk about next section. Yes, let me see. Okay, section 6 you didn't understand. Section 6 basically talks about, I think section 6 we dealt with in our previous, session. You have to go through the session again, but it is basically section 6 is talking about a situation of implied repeal. If I may tell you, section 6 basically is talking about effect of repeal. Okay. And effect of repeal, basically it is giving you 5 situations. So what happens when there is a repeal? Okay. So it says, where this act or any central act or regulation made after the commencement of this act repeals any enactment, then hereafter to be made, unless a different intention appears, repeal shall not do the following things. And it lists 5 items. Okay. And one first item is saying that it will not revive anything not in force or existing at the time for which repeal takes effect. So it will not bring in new situations. It will not, introduce new situations which was not there before the repeal. This is one point. Second point, it is saying affect the previous operation of any enactment so repealed or anything duly done suffered thereunto. So this is basically trying to say that if there is something which has happened in the repealed law, like say for example a right is accrued or somebody has suffered a liability, that particular thing will not go away. It will continue. Okay. Third, it is saying it will not affect the right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. So, if, say, for example, there is a law under which a liability is incurred, and we saw 2, 3 examples also regarding that in our previous session. I would encourage you to please go through the recorded video of the previous session. It will give you more clarity. And then the fourth point is affect any penalty, forfeiture, or punishment. So if somebody has incurred a punishment in the repealed law, that will also not go away. We saw the example that if someone, say for example, income tax law had a penalty which later on went away, like we can take an example of decriminalization of company law. A number of provisions under the Companies Act have been decriminalized now. So say for example, decriminalization happened from 1st of April 2025. So any offense which has been done with that particular provision prior to 1st April 2025 will not go away because it is repealed now. Am I making sense? So it is basically the action which you have done in the previous law will not go away, including any right, any privilege. I hope this gives you clarity on section 6. Okay. This is called repeal. Repeal or effect of repeal on effect of repeal. Okay. Now let me move further and talk about the section 9, which is an interesting section, and it says commencement and termination time, termination of time. Okay. And if you go through the legislation, it goes like this, and it says, in any central act or regulation made after the commencement of this act, it shall be sufficient for the purpose of excluding the first in a series of days or any other period of time to use the word from, and for the purpose of including the last day in a series of days or other period of time to use the word to. This section applies to all central acts made after the third day of January. Now, see, it is quite simple, but it has got a lot of repercussions. Okay. Because when the law starts applying and to what time the law should be applying is something which can be decided by the word from and to. So it is very, 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 nuanced section, and you have to understand that because application of law will be depending on that, right? Like, say, for example, we are talking about taxation legislation. So there is a particular date from which it will apply, right? So say, for example, we say that the new taxation regime will apply from the new financial year. So from when we say it is basically 1st April. So when is that 1st April coming up? That 1st April gets triggered at the midnight, isn't it? You would all recollect when we had this Bharatiya Nyaya Sanhita notified, I think 1st of July 2024, the law struck up and it was covered by many news channels that at 12 midnight, the law was, came into force. So that thing is giving, that interpretation is given here, or clarity is given here, that when the law will commence. So there is an example given in your booklet, and it says a company declares dividends for its shareholders in its annual general meeting held on 30th September 2022. Under the provision of Companies Act, company is required to pay declared dividend within 30 days from the date of declaration. Okay. So here the word from the date of declaration, that is from 1st 10 2022 to 30th 10 2022. In this series of 30 days, 39 2022 will be excluded, and the last 30th day, that is 30 10 2022, will be included. So this is what is the interpretation of this particular term. So when you calculate from to, you exclude the from date and you include the to date. This is what it is trying to tell you. You exclude the first day and include the last day in calculation of 30 days. I hope this is making it clear, because rationale I will tell you. It's like, say, for example, it is saying apply from 1st of April. Okay. And the instruction comes on 1st of April. So actually half of the day has gone, or maybe the full day has gone, or quarter day has gone. So hence you don't calculate that particular day. You leave that particular day and you calculate the days from the next day. And that is how you take the next day and then the last day. That is how you calculate that. This is how the rationale for commencement and termination of time. A simple provision, but technically, one has to read. Many a times we get caught up in this technical aspect. Okay. Yeah, I gave you the story. Now let us move ahead and proceed further. I will tell you these provisions. See, the General Clauses Act. To you people, maybe a general people, it will appear that why we are into so small things, and why there is a requirement of an interpretation for these small things, and you don't know. But if you have a look at it, there are litigations which are fought for even small comma in a statute, right? And I remember that so there are some cases in which people have lost crores and crores of rupees just because in the contract clause there was a comma missing or comma addition. Okay. And you will find cases. Maybe I will share it with you in our next interpretation session, and you will come to know that how important these small things are for a legal person. And many a times we get caught into these small things. And hence there is a requirement of a clarity, and General Clauses Act provides that clarity. Then there is a section, that is section 10, which talks about computation of time. Okay. So it says, where by any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court or office is closed on that day or the last day of the prescribed period, the act or proceeding shall be considered to be done or taken in due time if it is not done or taken on the next day afterwards on which the court or office is open, provided that nothing in this section shall apply to any act or proceeding to which the Indian Limitation Act 1877 applies. Now, this exception is for a simple reason that Indian Limitation Act 1877 factors in this computation of time in itself, because Limitation Act is meant for computation of time. So it provides for all situations. Hence, there is an exception created for Indian Limitation Act. But say, for example, there are no Indian Limitation Act application for a situation, then you come back to the General Clauses Act for computation of time. It basically says that if there is a law which applies and on the 30th day or on the X date, it falls a Sunday or a holiday, then you need to exclude that particular day and the next working day will be considered as the that 30th day. Okay. So let us look at this situation. A central act requires an appeal to be filed within 30 days or maybe 45 days. And the 30th day falls on Sunday when the court is closed. So application of section 10 here would be, since the last day falls on a day where the court is closed, filing on the next working day, that is Monday, is considered within time. So conclusion here is that the appeal filed on day 31, that is Monday, is valid. So I hope this particular provision is very clear. There is nothing much to talk about this particular provision because it talks about extension. Similarly, it happens next working day, which is there. Many a times we also do that. Like, for example, this semester, I gave my students assignment that, okay, submit the assignment within 15 days. And on the day on which I gave the assignment was, a working day. However, the 15th day fell on a holiday. So now, naturally, now law students didn't have to be taught this. They knew that, yes, next working day will be our 15th day. So that will be considered. So this is how you need to interpret. This is a basic understanding of computation of time. Am I clear to this? Any question till this point? Any one of you? Any question on this? Okay. If you don't have any question, let us move ahead and talk about another situation. Here, I would also like to talk about one interesting, dimension or case was that many a times courts also give, exception of time while calculating this particular time. Like, for example, during the COVID period, if you would recollect, during the COVID period, Supreme Court actually extended all these particular timelines, right? So it was a suo motu case in writ petition number 3 of 2020, and by way of an order dated March 2021, all these periods, the statutory periods which were mentioned, were extended. It was not under General Clauses Act, but by suo motu action, Supreme Court actually extended the period from 15/3/2020 till 14/3/2021 as country faced the COVID-19 pandemic. So there are exceptional situations also where courts can provide some relief to people. So I hope this example sets the context for you. Now let me move further and talk about three other sections. The one section is dealing with measurement of distances. So wherever there is a requirement of measuring a distance, so it says in the measurement of any distance for the purpose of any central act or the regulation made after the commencement of this act, that distance shall, unless a different intention appears, be measured in a straight line on a horizontal plane. So it has to be on a straight line on a horizontal plane. Okay, it cannot be a circuitous route. I'll give you an example, an interesting example. You may all be knowing that there is a restriction of, smoking near the educational institution. The distance is 100 meters. If you see this, there was a Supreme Court decision which said that the liquor vending shops cannot be near the highways. and it prescribed a distance. Do you know what is the distance? Can you put it in the chat box? How much was the distance in that case? Any one of you, if you remember? Yeah. Uh, Distance between the highway and the liquor vending shops. Yeah. It was not 100 meters, 30 meters. No. Yes. How much distance it was for liquor vending shops? Yeah. Yes. So it was 500 meters. Very true. And the court said that 500 meters is the distance. Now, this 500 meters is to be measured by a straight line. You cannot say that, okay, fine, there is a zigzag route and it is only 100 meters and you calculate that by way of a zigzag route. So people are smart, no? So that is why law basically provides very clarity. So there is a when you measure a distance, you will measure it by way of a flying crow. So it is the airline distance, not the distance by way of a road. So that is what it is, looked at, right? So please see it from that particular perspective. The distance, measurement of distance has to be in a straight line. That is what it is trying to tell. Now, this distance part of it becomes very important in many situations. Like, for example, when you are calculating the territorial waters, when you are calculating the continental shelf, particularly in maritime laws, this measurement of distance becomes very important. So, say, for example, the limit of territorial waters is 12 nautical miles. So, this 12 nautical miles is in a straight line, it is not zigzag. Okay. And similarly, if you look at for the contiguous zone, it is 24 nautical miles, like that. So you have to see it from that particular perspective. I hope this is clear to you people, measurement of distance. Okay. Yes. Now let us move ahead and talk about the next one, which is talking about duty to be taken pro rata in enactments. Okay. So pro rata in enactments means what? So whereby any enactment now in force or hereafter to be in force, any duty of customs or excise or in the nature thereof is leviable on any given quantity by weight, measure, or value of any goods or merchandise, then a like duty is leviable according to the same rate on any greater or less quantity. So, say for example, there is a statute which says that there will be a duty on a particular, say for example, there will be a duty of 100% on import of 1 kg gold. Now, if that is the provision, then in that situation, if someone brings 200 kg of gold, then there will be a pro rata customs duty on that. Or say, for example, somebody brings 500 grams of gold, then there will be accordingly a less quantity or less pro rata basis. So it is basically saying that irrespective of the provision, it should be on a pro rata basis, right? Otherwise, what will happen is if the provision says like this and there is no interpretation under section 12, even if somebody brings 750 grams of gold, the customs officer will say, no, no, law is saying 1 kg and this much of amount. So you have to pay this much of amount, whether you bring 500 grams or you bring 1 kg. So generally you will remember, right? This is called minimum commitment rate in hotels. So they will say that, yes, law says this is minimum commitment rate. You have to pay this much only. That is why this provision becomes very, very important for them. I hope you get this particular provision. Yes, pro rata means proportionate. Very true. So this is how the provision means. Is it clear to you? Anyone, any question till this point or any comment you want to make on pro rata basis? Okay. If there are no comments and questions, let me proceed further. Okay. Next, section 13 talks about gender and number. And it says in all central acts and regulations, unless there is anything repugnant in subject and context, words importing the masculine gender shall be taken to include females. And nowadays, even transgenders, right? So there is a change in the General Clauses Act in 2024, probably. and they have included transgenders also into this particular provision. So it is saying that wherever in a legislation it talks masculine, most of the places you will find he in the legislation. The trend is changing now. They are adding she to it, and probably now they will be moving to they. There is a requirement now that it should laws should be gender neutral. That is what is a discussion going on. Let us not go into the details of it, but General Clauses Act basically says that wherever you are having the masculine gender mentioned in the law, you should consider it to include females in wherever required, as well as transgender nowadays. And further, it says that the words in singular shall include plural and vice versa. So you have to interpret that in terms of the context, right? So if it is saying plural, then it has to be plural. If it is saying, singular, then it has to be singular, irrespective of the fact that it is not mentioned in the law. Now, there is interesting here that there are certain legislations wherein they will be using the word women specifically. Okay, but generally in most of the laws it will be he. But there are some women-centric laws which requires specifically to mention women, and that is what it is there. Like, say for example, there is a law protection of women against sexual harassment at workplaces, POSH law. So it is meant for the women, and that is mentioned in the law itself. Now, any question till this point? No question. Let us move further, and we talk about the next chapter, which talks about powers and functionaries. Right. So this chapter of General Clauses Act, ranging from section 14 to 19, talks about powers and functionaries. So this is basically meant for the administrative flexibility and continuity actually embedded in statutory frameworks. They are basically designed to address issues relating to succession, delegation, and maintenance of authority within various levels of functionaries, ensuring smooth governance. So governance requires that there should be smoothness of functioning. You want to function in a smooth way. Otherwise, what will happen is that whenever there is a vacancy in an office, the office, you don't know how the office will continue. So in government, you will see that government keeps on going, irrespective of the fact that the person is there or person is not there. There may be a bit of a hustle bustle, but generally you will find that there is a person next to or in a succession line who takes over the company or maybe who takes over the authority. So with reference to that, these provisions are meant. Okay. Now, if you see, these are the provisions. Section 14 talks about powers conferred to be exercisable from time to time. And it basically says that wherever there is a power which is conferred, then unless there is a specific, law or a direction which specifies otherwise, the power may be exercised from time to time as the occasion arises. So, say for example, a power is given to the district magistrate every time that power has not to be conferred. District magistrate has power to administer and he will keep on administering. So, there is whenever a situation arises, he will have that particular power to exercise. Then there is power to appoint, to include power to appoint ex officio. So it is saying that if you want to appoint, if you have a power, if the authority has a power to appoint, that is what the law says. Let us read the law. It says, whereby any central act or regulation, a power to appoint any person to fill any office or execute any function is conferred, then unless it is otherwise expressly provided, any such appointment, if it is made after the commencement of this act, may be made either by name or by virtue of office. So it is not necessary that every time the appointment will be by name. Many a times the appointment can be by virtue of office also. Okay. Now, power to appoint to include power to suspend or dismiss. So this is a very basic power. Anybody who has a power to appoint has also a power to dismiss and suspend that particular person, provided you meet the requirement of suspension and dismissal, right? Then substitution of functionaries. So it says in any central act or regulation made after the commencement of this act, it shall be sufficient for the purpose of indicating the application of a law to any person or number of person for the time being executing the functions of an office, to mention the official title of the officer at present executing the functions, or that of the officer by whom the functions are commonly executed. So this is a very important section where you are trying to, give authority to the functionaries by way of a particular designation, and the official title of the officer is, given. Like, say, for example, the power of a district magistrate, if it is to be exercised by deputy magistrate or any assistant magistrate, then that can be always said that, see, the power of the deputy SP will be exercised by SP, or SP's power will be exercised by deputy SP. That is something which is called substitution of functionaries. We will talk about it more in a while. Then successors, and then official chiefs and subordinates. So let us look at the examples to get more clarity on this rather than going. Okay. Now, let us move ahead and talk about the first one. That is an example with reference to municipal corporation. So here, if you go ahead, it says the municipal corporation is tasked with managing urban development, enforcing regulations, and maintaining civic amenities. The municipal commissioner is the chief executive officer. So you must all be knowing the municipality, municipal corporation, municipal commissioner is the chief executive officer. It is a government position. Now, under section 14, that is saying power conferred to be exercisable from time to time. Here, the Act empowers the municipal commissioners to levy fines for illegal constructions. These fines are not a one-time imposition. They can be applied as often as violations occur, such as when unauthorized structures are repeatedly built in different parts of the city. So you can see this power is there for them to exercise again and again. So you see nowadays we are having that particular decision, bulldozer decision, so by the Supreme Court. It basically saying that there is power exercisable from time to time by the municipal commissioner, but there has to be fair procedure followed. That is what Supreme Court said in that decision. Okay. So here powers conferred by exercisable from time to time, but municipal commissioner does not require every time a permission from the state government. Power has been given in to the municipal corporation by virtue of its office, and they can exercise this power from time to time. Now, section 15 says power to appoint to include power to appoint ex officio. So here, municipal commissioner appoints an officer as the head of the health department. Okay, he has got the power to appoint a person as head of the health department. However, by virtue of this position, the appointee automatically becomes an ex officio member of Municipal Disaster Management Committee, ensuring the health perspective is considered in disaster planning. So there is a committee on health disaster management, municipal disaster management, and the head of the health department is ex officio of that particular position. So what happens? Anyone who is appointed, of that particular head as health department, he automatically gets the ex officio membership of a particular committee. Ex officio positions, you will find the number of ex officio positions. Like, for example, I enjoy an ex officio position in my academic council. So whosoever is the dean becomes the ex officio position in the academic council. So there are number of ex officio positions in government where the people become ex officio person of that particular organization. Now let us talk about another provision that is with reference to the power to appoint to include suspend and dismiss. So here in this situation which we are having a look at, the commissioner who has appointed sanitary inspectors to enforce cleanliness and waste management also have power to suspend inspector for neglecting duties such as failing to address persistent garbage collection complaints in a key residential area. Section 17 talks about substitution of functionaries. So here in this situation, which I have given the example, if the commissioner is on long medical leave, the deputy commissioner steps in to exercise the commissioner's statutory powers And this is substitution basically, right? So he is substituting the power of the commissioner. Deputy commissioner gets charge of the commissioner, and such as approving urban development plans and issuing licenses until the commissioner resumes the duty. However, there is a specific order which is given for this substitution by the state government, and then they are able to exercise this substitution. So this is like in charge registrar, in charge vice chancellor. So that is the thing which happens. Then section 18 talks about successors, and it says when the current commissioner retires, the newly appointed commissioner immediately inherits all powers and responsibilities without requiring any formal transfer. There is no need for a formal transfer. The handing and taking over should happen, or he should do something. As soon as the person is appointed, it may say with immediate effect or with effect from so and so date, the person gets the charge completely in his hands. Here you need to understand, to ensure governance and administrative functions like addressing encroachments or approving budget, etc., he will get an uninterrupted power. So whatever actions has been taken by previous commissioner will not become null and void. This new commissioner has to actually take over those decisions and has to comply with whatever things has happened. Like say, for example, there is a court case going against the municipal commissioner. So the new commissioner cannot say that, yes, I am the new commissioner. I don't know about the old commissioner, what they did. So they have to comply with whatever action has been done by way of a office. So there is something which is called corporation sole. So this is the office of a corporation sole. It continues irrespective of the person who is manning that particular chair. Then there is something which is referred to as official chiefs and subordinates. So here the chief engineer of the corporation delegates responsibility to assistant engineer to supervise the construction of drainage system in various zones of the city. While the chief retains overall accountability, subordinate carry out day-to-day operational tasks with their specific jurisdiction. Now here it is interesting to note that though the delegation has been given in this particular task to the engineer, but overall responsibility lies in the hands of whom? In the hands of the person who has got actual responsibility. So say, for example, if there is a responsibility of the district magistrate to look after a particular thing, he may delegate certain things to people to do, but ultimate responsibility lies on his head. So the person concerned, who is having that official responsibility will be responsible. Overall accountability will be lying on his head. However, he can get that particular work done from somebody else. So in this example, you saw how these principles work together to create basically a robust framework for governance, and it ensures powers are exercised effectively, delegated properly, and there is a seamless transition, and there is no problem in change of power. And you can see these are the things, if like say for example government changes, there is a peaceful transfer. One government gives power to another government if they are not winning the elections. Or say, for example, there is a nowadays, you must be seeing mayor elections or any other kinds of elections. So if the dispensation changes, there is a smooth transfer, and that is happening because of the provisions which has been given. So if there is confusion in this particular part anywhere by the government authorities or anyone, they can refer to the General Clauses Act and try to understand what it is trying to say. I think this particular provision was recently applied in one of the cases of the ED, that is Enforcement Directorate. There were some officers who got transferred or who got changed, and I think some provision was utilized in interpreting from the General Clauses Act. So this is about the officials from time to time. Any question till this point? Any one of you? Yes. I'm just referring to one literature. In case if I find something, I will tell you. But if you have any question in between, you can ask. I think I have given you the sufficient explanation. There's nothing much in this. Okay. Now let me proceed further. Yes, corporation sole means continuity of a public office by successor. It can be public office, it can be any other office also. Like say, for example, office of a chairman is also a corporation sole kind of a thing. Power will continue with successors. Yes. Uh, Singular and plural, which you have asked, Anil, is basically that if there is a word which is used singular in a statute and you have to apply this situation to multiple people, you can, that will be read as plural. Like, say, for example, it says that the offense is committed by one person and you find that there are five persons who have committed. So can we not prosecute five persons? Yes, we can prosecute the five persons. So it is basically saying that wherever in a statute you find a word singular and you want to apply it to many people, that is possible. This is what General Clauses Act says, that you have to see the context, and plural or singular will not hold you from applying that particular law to anyone else. Okay. Yes. Okay, now let us move ahead and talk about provision as to orders, rules, etc. made under enactments. So there are, five sections here. Section 20 talks about construction of orders, etc. 21 talks about power to issue, to include power to add to, amend, vary, or rescind notifications. 22 talks about making of rules or bylaws and issuing of orders between passing and commencement of enactment. 23 talks about provisions applicable to making of rules or bylaws after previous publications. And 24 talks about continuation of orders, etc., issued under enactments, repealed and re-enacted. Okay. Now let us look at these particular sections one by one. The first one is construction of orders, etc., issued under enactments. So it says, whereby any central act or regulation, a power to issue any notification, order, scheme, rule, form, or bylaw is conferred, then expression used in the notification, order, scheme, rule, form, or bylaw, if it is made after the commencement of this act, shall, unless there is anything repugnant in the subject or context, have the same respective meanings in the act or regulation conferring the power, right? So it is basically saying that wherever there is a power which is conferred, it will have the similar kind of a meaning. Let us look at this example. It is there in your state book also. It says the term collector used in Rule 4 of Land Acquisition Companies Rule 1963 will have the same meaning as in Section 3C of the Land Acquisition Act of 1894. Now, you remember our previous section that if the law gets reminded. Now, in your example, you have to substitute Land Acquisition Act 1894 with the latest law of 2013. Now let us look at it. In Subhash Ram Kumar versus State of Maharashtra, it was held that notification in common English acceptance means and imply a formal announcement of legally relevant fact, and notification published in official gazette means notification published in by the authority of law. It is a formal declaration and should be in accordance with the declared policy or statute. Notification cannot be substituted by administrative instructions. So wherever there is a word notification issued, notification means official notification. It is not administrative instructions by way of a written instructions just like that. Notification means it has to be notified in a proper way. This is what this clause is trying to. Bylaws, Harivansh, means basically that bylaws are generally for societies. So if you see, it is way of functioning. So you can say, like, for example, we are having articles of association in company. These are kind of a bylaws. Okay. Similarly, for societies, there can be bylaws. So bylaws are basically made by the society, and they are under the main law. So under the Society Registration Act, there are bylaws which are made. So these are different terms used. So bylaw is a lesser nomenclature than law, you can say, or a rule. So rule is more firm. Bylaw is by way of daily functioning, but it is also important in terms of law. Okay. Right. Let me have a look at this is section 20. Yes. Any other question till this point? Okay. Now let us take you to section 21. So section 21 talks about power to issue to include power to add to, amend, vary, or rescind notifications, orders, rules, or bylaws. So it is saying that wherever there is a power to issue notifications, orders, rules, or bylaws to any authority is conferred, that power will include, uh, to add. So this power will include to amend that particular thing, vary, or rescind any notifications, orders, rules, or bylaws so issued. So say, for example, there is a power to the DM to issue a notification for unlawful assembly, against order against unlawful assembly. The same DM has a power to rescind that. So say, for example, a dean has a power to suspend a student from a particular thing. He has a power to, cancel that suspension also. So this is what it is exactly trying to say, that if an authority is having a power to do something, it has also a power to amend that thing, rescind that thing, or vary that particular situation. So in Rasid Javed versus State of Uttar Pradesh, Supreme Court held that under Section 21 of the Act, any authority which has power to issue a notification has the undoubted power to rescind or modify the notification in like manner. Then in another case, that is Shri Siddhabali Steels Limited, Supreme Court held that power under Section 21 of the Act is not so limited to be exercised only once. Power can be exercised from time to time, having regarding the exigency of the time. You recollect the provision on the 21. So this is the power which is not a power only exercised once. This can be exercised as many times it wants. Now 22. Section 22 talks about making of rules or bylaws and issuing of orders between passing and commencement of enactment. So whereby central act or regulation, which is not to come into force immediately on the passing thereof, a power is conferred to make rules or bylaws or to issue orders with respect to the application of the act or regulation, or with respect to the establishment of any court or office or appointment of any judge or officer thereunder, or with respect to any person by whom, or the time when, or the place where, or the manner in which, or the fees for which anything is to be done under the act or regulation, then that power may be exercised at any time after passing of the act or regulation, but rules, bylaws, or orders so made or issued shall not take effect till the commencement of the act or regulation. Now, this is a very long section, and you may be wondering that why this is so long. Basically, it is talking about a situation where you have passed the act, but rules are yet to be made, bylaws are yet to be made, regulations are yet to be made. Regulations, bylaws, rules are made for multiple purposes. It may say that law will come into force when, which will be the place where the law will come into force, or manner of fees, etc., etc. All these things, rules and regulations can be made, power is given to the respective authorities. However, none of these authorities can implement the regulation till the act is notified. Okay. Am I making sense to you? Let me give you two examples. One example is coming from competition law. So you all know that Competition Act got passed in 2002. And there were various regulations which were made by the Competition Commission at that point in time. However, these regulations could not be notified because the substantive provision were not notified. Like say, for example, there was general regulation which was made, but general regulation cannot be notified because section 3 and 4 were not notified. So once section 3 and 4 got notified, that is the act parent legislation, then only the regulations could be notified, rules could be notified. Similarly, you can see Mediation Act has come into picture. Mediation Act is also enforced only in part. It has not been enforced fully. Now the rules are being made. Now, if rules may be made, but rules cannot come into force before the act. So the first enabling provision of making of rules has to be notified, and then only the act will be notified, and then only the regulations can be notified. This is what section 22 makes it very, very clear. So it says subordinate legislation supplements the principal act. Okay. So this section basically permits making of subordinate legislation immediately after passing of an act. And in many cases, there is a gap between passing of an act and commencement of the act. Strictly speaking, subordinate legislation is to be made only after the commencement of the act. But this section permits making of subordinate legislation after the passing of the act. But such a subordinate legislation will take effect only after the commencement of the act. Subject matter on which subordinate legislation could be made includes the establishment of any court or office or the appointment of any judge or officer or the manner and the form in which fees is to be paid. These are the things which have been mentioned in this section. Now, let me take you further and talk about section 23, and it says provisions applicable to making of rules or bylaws after previous publication. So see what it says. It says whereby any act or regulation, a power to make rules or bylaws is expressed to be given, subject to condition of the rules or bylaws being made after previous publication, then the following provisions shall apply. Which are the provisions? The first one, the authority having power to make the rules or bylaws shall, before making them, publish a draft of the proposed rules or bylaws for the information of persons likely to be affected thereby. So say, for example, there is a rule which is coming under Land Acquisition Act, which is affecting the people who are having their land and getting acquired, or maybe there is a notification to that effect. It is basically saying that if you are affecting any right of a people, then before you make these rules or bylaws, that should be published as a draft to people. This is what it is trying to tell. Second point, it is saying the publication shall be made in such manner as the authority deems to be sufficient, if the condition with respect to previous publication so requires, in such manner as the government prescribes. So generally nowadays, you will find that the legislations are notified in advance and the information is given to people for that. Now, let us look at next one. There shall be published with draft a notice specifying a date on which the draft will be taken into consideration. And fourth, the authority having the power to make rules or bylaws, where the rules or bylaws are to be made with the sanction, approval, concurrence of another authority, the authority also shall consider any objections, suggestions which may be received by the authority having power to make rules. So any objections which have been received, they should consider that. And fifth, the publication in the official gazette of a rule or bylaw is a conclusive proof that the rule or bylaw has been made. So what is the proof of a legislation? It is the publication in the official gazette. I can give you one example. This is the publication of draft rules. So you see, now this rule has been also notified. You people all may be knowing that the digital personal data protection rules have been notified now. But before that notification, on 3rd January 2025, there was a draft rule which was, given in public. So you can see here, the draft rules are given in public. Objections and suggestions, if any, may be submitted on the website of so-and-so by said date. So they asked for a suggestion by 18th of February 2025. This date was also extended. And then now, after considering everything, they have published the Digital Personal Data Protection Act 2025. So you see how the consultation process or this process happens. Now, the 24 talks about, let me take the, yes, rules are category of subordinate legislation. Yes, by law. Okay, fine. There are no more questions. Now, let me see the 24th. So 24 says, continuation of orders, etc., issued under enactments, repealed and re-enacted. So it is saying basically, if you see here, we are talking about where any central act or regulation is, after the commencement of this act, repealed and re-enacted with or without modification, then unless it otherwise expressly provided any appointment, notification, order, scheme, rule, form, or bylaw. So I think this term has come again and again. So now you should be used to it. They are using different forms of orders and this. So it's saying unless it is otherwise expressly provided, any appointment notification, order, scheme, rule, form, or bylaw made or issued under the repealed act or regulation shall, so far as it is not inconsistent with the provisions reenacted, continue in force and be deemed to have been made or issued under the provisions so reenacted, unless and until it is suppressed by any appointment notification, order, scheme, rule, form, or bylaw made, issued under the provisions so reenacted, and when any central or regulation which by notification under section 5 or 5A of the Scheduled Districts Act. Now see, this is a very long section. I don't want to go into the details of it. It is basically trying to tell you that whenever there is a repeal or any reenactment of a law, what will happen? So nowadays, this particular problem is solved by way of uh, the provisions by way of the repeal and saving clauses. So you will see in most of the legislations, this is a provision, section 24 basically is a provision which was meant for legislations which have been repealed or reenacted. So nowadays you will find that in many of the legislations you have repeal and saving clause. So the repeal and saving clause is there in, I have given an example of section 66 of the Competition Act. This is a repeal and saving clause. Here you can see it is saying basically subject to the provision of subsection 3, all cases pertaining to unfair trade practices other than those referred to in so and so will go to the competition under the Competition Amendment Act, and the provisions, some cases will go to the National Commission, that is a Consumer Dispute Redressal Commission. So the legislation which is repealing or which is coming up with a new law will be making the provision for the existing cases, for the existing what you can say existing cases and existing investigation, how that will be dealt with has been talked about in this particular provision. So this is what section 24 says, and let us move ahead. Now I want to go ahead with that, but that I will go ahead after the break. But till this point, any question, any one of you? Yes. Yeah. Yes. Are there any questions? Any one of you have any questions? Yes, if there are questions, I will be happy to answer. Any one of you till this point, any question or any situation you would like to discuss with me, I'll be happy to discuss. Yes. Any questions? Any one of you? I'm just observing the chat box. Yeah. Okay. If there are no questions, then we take a break. We will resume this session at 17:30. Okay. In the meantime, you can think about some situations where you have some questions or any clarifications you want. I'll be happy to take up that. Okay. The Kuldeep, the difference between the rules, regulations, and bylaws are quite distinct. I gave you this particular definitions before also in our session, but I'll explain again. So when I say act is by way of a parliament. When I say rules are subordinate to act, and this is generally by way of a government. So wherever you will find in the central legislations, they use the term central government. Wherever there is a central government, depending upon the legislation, central government gets decided by way of the ministry. Like say, for example, if the law relates to agriculture, agriculture ministry will be the central government as per the allocation of business. If it is Companies Act, central government is Ministry of Corporate Affairs, right? So like that, the rules are made by these ministries. That is called rules. Subordinate to rules, or you can say further subordination is by way of regulations. So the regulators makes the regulations. Like say, for example, we are having SEBI as a regulator. So SEBI makes the regulations of the securities market. They are also laws by under Article 13 of the Constitution of India. Similarly, if you have Companies Act, if you have, say, for example, NCLT, if you have IBBI, so Insolvency Bankruptcy Board of India makes regulations for insolvency professionals and any other regulations like that. So these regulators make the regulations. When I say bylaws, bylaws are basically further down in the delegated legislations, and bylaws are made by organizations basically for their functioning, day-to-day functioning or daily functioning. Generally, bylaws are made by societies. Regulations till the regulations are made by till the regulators. Bylaws are made by societies. Bylaws are made by organizations, and they are also kind of a law, right? So you can see, say, for example, bylaws, there can be bylaws by uh, a trading society or maybe an organization that is referred to as bylaws. Okay. So I hope this gives you clarification, Kuldeep. If that is fine, then we meet after the break. Okay. Welcome back to the session, all of you. And we will move ahead with understanding the other part of the General Clauses Act that deals with miscellaneous provisions. And there are five sections, six, seven sections to this, 25 to 30. And we will be discussing about these miscellaneous provisions. Let me move ahead with the first one. And the first one talks about recovery of fines. So if you have a look at recovery of fines, section 63 to 70 of the Indian Penal Code, and it reads like this: section 63 to 70 of Indian Penal Code and the provisions of the Code of Criminal Procedure for the time being in force in relation to the issue and the execution of warrants for the levy of fines shall apply to all fines imposed on any other act, regulation, rule, bylaw, unless the act, regulation, rule, or bylaw contains an express provision to the contrary. So, your section 25 of the General Clauses Act provides for the recovery of fines. And if we may have a look at the provision of the recovery of fines, it is basically trying to tell you that irrespective of the provisions of Code of Criminal Procedure, for the timing in force. So anything which you want to do with execution of warrants, or you want to do levy of fines, will be applying to all other provisions. So if nowadays, if you will look at it, for recovery of fines and for the procedure of penalty, you have an exception created. So if you see the new modern legislations, they are saying that penal code and procedure will not apply because they are having their own procedures, a simplified procedures, a sample procedures, and they are saying that, okay, fine, these will be applicable and the general provision which is there in Code of Criminal Procedure and IPC will not apply. This is the modern legislations. If you see the new legislations, that is what it is happening. But if the legislation does not mention that, then in that particular situation, you have to go back to IPC and CRPC, that is Code of Criminal Procedure. Now, Bharatiya Nagrik Suraksha Sanhita, that is what is the change which we have made, and Bharatiya Nyaya Sanhita. These are the two legislations which will be applicable for recovery of fines. There is not much to interpret on this particular provision. It is a very plain and simple provision which says that wherever there is a penalty, wherever there is a procedure of penalty to be followed, you refer to section 63 to 70 of IPC, and provisions of Criminal Procedure Code for the timing in force will be applicable unless the law tells you otherwise. Section 26 of the General Clauses Act says provisions as to offences punishable under two or more enactments. So when an act or omission constitutes an offence under two or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be liable to be punished twice for the same offence. So this particular provision, which you are able to see, it is basically saying that if you are having, offense, you have made an offense under two or more enactments of the by way of a same action or by way of a same act, then you will be liable to be punished and punished under any of those enactments, but you should not be liable for punished twice for the same offense. This provision, punishment twice for the same offense, comes from Article 20 of the Constitution of India, which basically prohibits double jeopardy. So there is a right of people that you cannot be punished for the same offense twice. Once you have been punished, then you cannot be punished on the same offense. However, same set of facts may lead to two different offenses under two different legislations. Okay, then in that situations, your action may take you the proceedings in different sections also. I will give you an example. Like say, for example, you are under or someone is under corruption or does corruption and uses that particular money and transports that money somewhere else or whitewashes that money, then Prevention of Money Laundering Act also applies to the same action, right? So the proceedings under two legislations will continue automatically. Okay. Now, say for example, there is a person who has an illegal arms in his hand, and by this arms he kills someone. Now, possession of the illegal arms is an offense under the Arms Act, and then he has committed a murder, so that is another offense under the Bharatiya Nyaya Sanhita. So these are the two offenses, but coming from the same act, he has used the illegal weapon and then he has killed the person. So it cannot be tried in the same thing. There are two things which are getting tried, but he is not getting punished twice for the same offense. There are two different offenses arising out of the same act or omissions. I hope this gives you clarity. So it is basically trying to provide you a clarity in terms of punishment of offenses under two or more enactments. I hope this is clear to you. Then I have already told you about rule against double jeopardy. That is Article 20, subclause 2 of the Constitution. It says no person shall be persecuted and punished for the same offense more than once. So in the case of state of MP versus VR Agnihotri, it was held that when there are two alternative charges in the same trial, example section 409 of the Indian Penal Code and section 52 of the Prevention of Corruption Act, the fact that the accused is acquitted in one of the charges will not bar his conviction on the other charges. Okay, I have given you the example, the similar kind of an example before. Are there any questions on this? Let me see the chat box. Okay. So this punishment part which you are talking about, whether the second punishment will be completion of the first, depends on the judgment. So any case where there is a punishment, see the criminal trial also or criminal cases also, it is in two stages. First stage is referred to as conviction stage. Okay. So in the cases, first you decide whether the person is convicted or not. Okay. Once you decide that the person is convicted, then you move on to the punishment stage. So there is a separate discussion or hearing which happens on punishment, and at this particular stage the court decides whether the punishment will run concurrently or whether the punishment will run consecutively. So if court decides that the punishment should run concurrently, then all these punishments of all offenses will run together. So the person, if he is punished for one offense for 6 months, another for 10 years, another for 5 years. So maximum punishment for that person would be 10 years, right? But if the punishment is consecutively given by the court, then in that situation, the person has to undergo each of these punishments separately. So first he will go for 6 months, then again his new period for another offense will start for 5 years. Then once he completes that 5 years, then another punishment for 10 years will continue. Like this, the consecutive punishment happens. So it depends that what kind of a punishment has been given to a person concerned. Depends on the gravity of the offense also, and that is how it is working. Okay. Yes, Mustafa, you don't have to remember these particular cases. You just remember the factual situations. But if there is, if you remember, it is better. Now let us move ahead with the other questions under the same act and be punished twice for the same offense. Yes, yes, definitely. That is what Shamli I have tried to explain you, that if for the same act the person concerned has done an offense which is punishable under two different acts, then definitely he can be tried for under the two different legislations. Okay. Okay. Now let us move ahead and talk about the other provision. And this provision relates to service by post. This is a quite an interesting provision. And for service, you have to also read the Code of Civil Procedure. So Code of Civil Procedure also gives you much detailed understanding of what do you mean by service. So here it says where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either of the expressions give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying, and pasting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in an ordinary course of post, will be considered as a service. Now, why this is important? Service is important because many a times the court would ask whether you have served upon the opposite party, whether you have given the importance of this particular, the notice of this case to the other party, because nobody should be left unheard. This is the basic principle of natural justice. And the other party, this can be of a hand, by way of a dasti, by way of a registered post, by way of a telegram. There can be done, service can be done by multiple ways. Now you may have a question whether the service on WhatsApp will be accepted. Now I think courts have consistently said that service on WhatsApp is not acceptable, right? Particularly in criminal trial, they are not accepting service by WhatsApp. Or service by mail, can it be accepted? Yes, service by mail can be accepted under the Information Technology Act. That will be considered as a service. But you need to have a technology which tells you that the other person has got that particular mail. Because nowadays in mail, you know that the mail can go into spam or mail can go into some other place. Person has not received it. So you must have some technology which is acceptable by the court, which tells that yes, your mail was received by the other party. So all these things are emerging. Nowadays, new technology is also emerging. So things are getting changed. But this is a General Clauses Act, which is of age old act of British era. But still, this mean service by post holds good. So Code of Civil Procedure Order 5 provides several modes of service. I was talking to you about that recently. Now you see, in this particular case, United Commercial Bank versus Bhim Sen Makhija, a notice when required, it was held by Delhi High Court, that a notice when required under the statutory rules to be sent by registered post acknowledgement due is instead sent by registered post only. The protection of presumption regarding service of notice under registered post under this section of the Act neither tenable nor based upon sound exposition of law. So see, what was held in this particular case. So it is saying here the service by post has to be by way of properly addressing, prepaying, and posting by registered post a letter containing the document. Okay. So a registered post is very, very important. Registered post acknowledgement due is instead sent by registered post only. Then in that situation, it will not be accepted as registered post. Registered post will not be accepted as a requirement, because here you can see it is saying what provision is applied. Can you people, talk about this example? So you just see the example. Okay, it is saying registered post acknowledgement due. The statutory rule said registered post acknowledgement due. Instead of that, the person posted registered post. But if you see in the General Clauses Act, it is only talking about registered post. It is not talking about registered post acknowledgement due. So can it be considered as a proper service? Yes. Any one of you? Just have a look at it. This is a problem. Interesting one. No. Why? No, acknowledgement word is there. But if you read it from section 27 of the General Clauses Act, where from you can get the exception? Use the term. Just see the term. Okay. Yeah. Let us see. Serve. Okay. No. No, that is fine in the civil procedure. I am talking, we are reading basically General Clauses Act. So let us focus on that. So in that legislation, it is saying, but where do you get the exception? If somebody, says that, okay, fine, General Clauses Act says registered post, not registered post due. So can we apply that? Ah, very good. Contrary is proof. Thank you, Deepak. Deepak, it is a good, that is what exactly we have to read. So it is saying unless the contrary is proof. Very good. So it is saying unless the contrary is proof to have been effected. So this term is an exception, right? So in a general circumstances, it will be registered post. If nothing is mentioned, then registered post will be considered as a service. But if the law or rule specifically mentions that it has to be registered post acknowledgement due, then it has to be registered post acknowledgement due. Then registered post will not be applicable. So as I told you before, that the special law takes precedence over the general law. So General Clauses Act is a general law. And what is that statutory rule is a specific law. So very good. I am very happy that you are able to understand this. Okay. Now let us move ahead and talk about what else is there in this slide. There is another case. Okay. So it says in Jagdish Singh versus Nathu Singh, it was held that where a notice is sent to the landlord by registered post and the same is returned by the tenant with an endorsement of refusal, it will be presumed that the notice has been served. So, refusal of a registered post will not be considered as non-delivery, right? So many a times you will find that notices are sent and people take that particular. The third point is in the case of Srimati Vandana Gulati, Allahabad High Court, it was held that where notice sent by registered post unless contrary is proved. So endorsement not claimed, not met is sufficient to prove deemed service of notice. So there is something which is called deemed service of notice. So if a person who has not claimed or not made is considered to be a sufficient proof of notice. Now here see there is something in CPC, we call it alternate service. Okay. That is done by way of announcement in the newspapers, and that kind of activity is done to complete the service, or it is also called substituted service. So this is yes, refusal amounts to acceptance and service. Yes, that is what the case law says. Okay, now let us move ahead and talk about 28. So section 28, any questions in the previous section? Yeah, on service, any one of you? Any question? If there are any questions, I will be happy to answer. Yeah. Any questions on the service part, service by post? No. Okay. If the post is missing, okay. The post cannot miss, post is missing will not happen generally because it is registered post, so it has to be accounted. So it cannot miss like that in between. So the postman has to give some answer to it that whether the post has been sent or not sent. Okay. Service by courier is acceptable. Yes, nowadays service by courier is acceptable. That is very much, but it is saying registered post, registered courier. So there has to be, courier is acceptable, but it has to be having proper registration and proper way. But in court matters, generally people prefer the government, posting mechanism. If it is registered post, you use the Department of Post and then do it. It is very authentic. In it has to be, delivery of email. Generally, the nowadays email as a service may be accepted, may not be accepted because there are a number of technical aspects to it. You have to see that computer system is fine. There may be objections saying that my system was hacked, and all those particular things come up in email service, right? So if the other party is accepting that, okay, fine, I received the email, then there is no problem. That notice is done. But if other party is objecting to it, that, okay, fine, I never received your email, then you will say that, okay, fine, I have a read receipt. Then the other party will object to it that this is a manufactured read receipt. Then you have to do a process, there you have to bring Information Technology Act, you have to bring the technician of your computer system to certify that the system is, sufficiently, soundproof, security, all those particular things will continue if you are going ahead with the email as a service. I hope you understand the complications, and hence to avoid all these complications, people go ahead with registered post. Okay. Mm, yes, board meeting, there is a separate process that is accepted through email because that is there mentioned in the, the secretarial standards. So it is perfectly all right. And that will come under unless the contrary is proved. Okay. So that is there. If it is mentioned in a statute that, okay, email will be considered, then there is no question, doubt at all. But if it is not mentioned, then by default, you cannot consider email as a service. I hope this makes sense to you. Okay. Now let us move ahead and talk about section 28. So section 28 talks about citation of enactments. So it says, in any central act or regulation and in any rule, bylaw, instrument or document made under or with reference to any such act or regulation, any enactment made by may be cited by reference to the title or short title, if any, conferred thereon, or by reference to the number and year thereof, and any provision in an enactment may be cited by reference to the section or subsection of the enactment in which the provision is contained. In this act and in any central act or regulation made after the commencement of this act, a description or citation of a portion of another enactment shall, unless a different intention appears, be construed as including the word, section or part mentioned or referred to as forming the beginning and as forming the end of the portion comprised in the description of the citation. This is quite a complicated, provision, which if you read, you will not be able to understand. Let me give you a simple example for making you understand this provision. So it is basically saying that the provision of section 5, say for example, there is a section citation. The provision of section 5 of Companies Act 1956 are relevant to corporate restructuring procedures. Now here, this refers to citing an enactment. Here, the Companies Act 1956 is cited using its title and for a particular provision such as section 5. Now there are general citations like in terms of Rule 12 of the Income Tax Act rules. Now here this cites the rule made under the Income Tax Act of 1961 by reference to its number and year. So these are the methodologies by which you can cite a legislation. Sometimes you say incorporation of provisions. So you say as per section 40 of the Consumer Protection Act, the terms outlined in section 17 of Competition Act are applicable. This basically shows how a provision of law could be cited along with another statute section with reference. You will see as part ahead, and bylaws made after the commencement of this act shall not affect the construction of any act, regulation, rule, or bylaw made before the commencement of this act, although the act, regulation, rule, or bylaw is continued or amended by an act, regulation, rule, or bylaw made after the commencement of this act. Section 29 basically avoids retroactive disruption by maintaining the stability and enforceability of rules and bylaws from repealed laws. This basically ensures continuity in governance, reduces uncertainty, and upholds past actions conducted under earlier legal frameworks. So this is basically for the statutes or for legislations where repeal has been done or enactment has been repealed and no provision for dealing with that repeal has been provided. Then you refer to section 29. Otherwise, I have shown you, if I gave you example of section 69 of the Competition Act. Generally, the legislations nowadays provide for the saving clause in the legislation itself. So you don't have to come to the General Clauses Act. If the legislation does not provide for the saving clause, then you move to the General Clauses Act for help. Now we talk about section 20, 30. That is the last section of the General Clauses Act, and it says application of Act to ordinances. So in this Act, the expression Central Act wherever it occurs, except in section 5 of the word Act in section clauses so and so, 20 section 25 shall be deemed to include ordinance. So basically it is saying ordinances which have been promulgated by the president. So you people must be knowing that when parliament is not in session and there is an urgency for the law to come into force, the president can come up with the ordinance, and this ordinance is valid till the next next parliament session ensues or comes into picture. So there are many ordinances which are passed. If you would recollect, there are a number of legislations which are passed by ordinance. So under the constitution, the power to make law rests with the legislature. However, in cases where parliament is not in session and immediate action is needed, the president can issue an ordinance. An ordinance is a law and could introduce legislative changes. So the Supreme Court has clarified that the legislative power to issue ordinances is in the nature of an emergency power given to the executive only to meet an emergent situation. An example of immediacy I can give you is by setting the ordinance passed in 2011 to give IIT Kanchipuram the status of an institute of national importance so that the students could be awarded their degrees on completion of their course. So these are the sections. Section 30 is a general application. So it is a clarificatory in nature. Section 30, it equates an ordinance as an act by fiction of law. And section 29 is a saving clause section. And this section explains the manner in which the construction of acts, regulation, and subordinate legislation made after the General Clauses Act and the construction of acts, regulations, and subordinate legislation made before the General Clauses Act has to be undertaken. So this is what is section 29 talking about. So this completes our General Clauses Act. Now we will go ahead with some cases which we will discuss, some problems. Okay. Now, if there are any question, let me see. I will catch up on that particular questions also first, and then we will go ahead with knowing and understanding the problems. Some problems we will touch upon, which will give you an understanding, and it is just a exercise which we are doing to understand how the problems are there in your examination. Okay, let me first answer your question, which is there in your chat box. Okay, under the right to information, as soon as the parliament ensures. Okay, anything else which you have a question? Okay, let us move ahead and talk about the some problems. So this is your first problem. You just have a look at it. And I would like to hear your solution. You can open your audio and you can speak about the solution, and then, or you can type it in the chat box as well. Go ahead. You can utilize the chat box to answer. 21st August. Okay. Any reason which you would like to give? Okay. Most of you are giving the right reason. Then it's 21st. Give me the reason also. Because since we have got the reason, which section of the General Clauses Act deals with this? As per which section of the General Clauses Act? Okay. Section 10 of the General Clauses Act. Okay, fine. Let us look at the solution. Thank you for your response. It is a good response. It says Section 10 of the General Clauses Act provides where by any legislation or regulation, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day, prescribed period. So we see the next day. That is what. So this in this case, promissory note was issued by Mr. Sohan to Mr. Mohan on 17th May, which was payable 3 months after the day. So after that, a sudden holiday was declared on 20th August due to Muharram. So in the given case, the period of 3 months ends on 17th August 2021. Now here is a catch. We are saying 3 months, right? So 3 months you calculate on the basis of months. But if it would have been 90 days, things would have been different, right? Because some months have 30 days, some months have 31 days. Then you have to calculate exactly the 90 days. Okay. So be careful in the question. If it is months, then you calculate months. But if it is days, then you have to exactly calculate the days. Right? Okay, very good. You people have got this particular question. Now let us move ahead with the next question. Okay, go ahead with this particular question. What do you think is your response? Yes, you can respond to the responses. Yes, please go ahead. Okay. Have you got the responses? Yes. Okay. Directory, it is mandatory or directory? You are saying directory. May shall take as mandatory as companies are not fired by unlawful purpose. Okay. May is not mandatory but directory. Okay. Let us see the responses. So what is the question? Question is Ayush and Vipul are good friends and pursuing CA course while doing group studies for the paper of corporate and other law. They are confused about the provisions of Section 3 of the Companies Act. The company may be formed for any lawful purpose by so. So whether it is may is directory or mandatory. So you see the word shall is used to raise a presumption of something which is mandatory or imperative, while the word may is used to connote something which is not mandatory, but in is only directory or enabling. However, sometimes word may has a mandatory force if directory force will defeat the object of the act. However, sometimes the word may and shall can be interpreted interchangeably. So this is a tricky question. You have to see from the facts and circumstances of the case. Okay. So if we have a look at this, so here in this case, Ayush and Vipul, two CA students are confused with the language of this section. Now, in the given case, it can be said that the word may should be taken as mandatory force because the law will never allow the formation of a company for unlawful object. Here, the word use may shall be read as shall. So, usage of word may here makes it mandatory. So, you will remember this particular problem we had seen in our assessment also. Okay. Okay, Mr. Linga, it is not directory, it is mandatory. Okay. Right. Now, let us move ahead and talk about. No, I think you will have you can mention this as an interpretation. It is not there, so you can just generally discuss means and shall. Yeah, I think that it is part of a definition clause. Okay, now let us move ahead. Next problem. Yes, can you read this problem and okay. Let me see your responses. Okay, NCGCA not changing New Companies Act. That is Companies Act shall be considered reference of old Companies Act. Okay, good. So let us look at the responses. So if you see here in this particular case, according to Section 8 of the General Process Act, so after the commencement of the repeals and reenacts or without modification, any provision of a formal enactment, then references to any other enactment or in any instrument of the provision so repealed shall, unless a different intention appears, be construed as references to the provisions so reenacted. So here you can see in Gauri Shankar Gaur versus State of UP, this is one of the cases. It was held that every act has its own distinction. Later act barely makes a reference made will have of the right. Okay, very. Now let us move ahead with the next problem. So this is a problem which you have a look at it and provide your response. Yes. Good. So you have got that particular thing of immovable property. That is a quite problem. You remember the fish problem. So that is relating to that. So you see, immovable property is defined in section 326, and it says it shall include land, benefits to arise out of land, and things attached to earth or permanently fastened to anything attached to earth. So it is an inclusive definition. It contains four elements: land, benefit to arise out of land, things attached to the earth, and things permanently fastened to anything attached to the earth. Where in any enactment, the definition of immovable property is in the negative and not exhaustive, the definition as given in the General Clauses Act will apply to the expression given in that enactment. So in the instead case, M sold land along with timber obtained after cutting trees of 50 tamarind trees, of his land. So according to the above definition, land is immovable property. However, timber cannot be immovable property since these same are not attached to the earth. Okay. So are you getting the point? Most of you answered immovable property. Uh, okay. I hope you got it. Yes. So Ms. Sharma, you have said immovable property. Now I hope you got this. Yes. So if it is separated till the time it is attached to the land, it is called immovable property. Once it is standing timber, it uses the word standing timber, not uses the word. So if it is standing timber, standing crops, that is part of the immovable property. But once it is severed and it is taken away from the land, then it becomes a movable property. It is no more immovable property, right? However, this is not the situation with fishing rights. So, but fish, if you take it out the fish and keep it in a bucket, then that is fish is not a movable property. It is a movable property. The fishing rights are immovable property. I hope this makes distinction is clear to you people. Good. Very nice. Now let us move ahead and talk about the next question. Have a look at it and give your answer. Okay. Some of you have answered. Let me see. Okay. Section 13. Okay. But masculine includes feminine. Okay. Let us see. Yes. So you are correct, all of you. So by virtue of provision 13 of the General Clauses Act, Central Act or Regulation, unless there is anything repugnant, the word masculine gender will be including females. So Ms. Nilu Chandra, Director of Laddu Sweets Private Limited, made an undue gain in the form of commission in dealing for so and so, but she denied accepting the liability by saying that the language of Section 166 provides penalty only for male directors, not for females, on the basis of the provision of General Clauses Act. So this is a pretty simple one. Okay, next. Okay, I think this one I forgot to mask the answer, but you can see here. So this is similar kind of a situation. Yogveer Singh has a mango orchard at Manchanga village. An orchard has more than 100 mango trees. Yogveer has sold orchard along with all mango trees. Now explain in this slide whether this is sale of trees will considered as sale of immovable property. What do you think? So sale of mango trees will be immovable property because they are attached to the land. Okay, so this is a distinction which is there. Now, let us move ahead with the next one. Yes. What are your answers? This is a calculation question, so you people are all potential CAs, so you should give me an answer. Yes, are we getting the answers? 750. Okay, Deepak, very good. But how you have calculated? Can you put the calculations? Okay, on a pro rata basis, right? So which section? Hmm. Very good, very good. So this is what good, Shamli. You have actually given the calculation. So this is how the answer is. So according to Section 12 of the General Clauses Act, whereby enactment now, force or hereafter, there should be proportionate basis, right? So this would be like this. $750 is your response. Good. Now this is the next one. Good, Steffi. You also calculated right. Right, Ms. Tiwari. Now you attempt the next one. Okay, I have got the first response. It is 15th July 2024 by Lesha. Good. 15th July, it will apply. President gave assent. Okay. Okay. Someone is saying September 1st. Okay. 1st September. Okay. Many of them are saying 1st September. Let us have a look at it. So, see, according of the clause on the that shall come into force on enforcement in 1st September 2024. So people who responded 1st September are correct. Many congratulations to you people. And let us now move ahead with the next question. So you don't have to hurry. The last lesson from the last question is that you have to read the question carefully. Okay. So please read the question carefully while you are answering this. Okay. Quickly, if you can answer this quickly, if I can get one or two responses. Okay, I got the first response. No. Okay. Let us look at the responses. So here you can see in this case, if the court considers Mr. N offense as a minor theft and believes it does not warrant harsh punishment, it might sentence him to simple imprisonment. However, if the theft involved force, it was committed in a violent manner, or if N has a history of criminal behavior, the court may decide to impose rigorous imprisonment. Okay. So this is what it is talking about. So you have to see it from that perspective. Let us look at the next one. Yes. Next. This is similar. We've seen this particular response before. So it is basically you have to see Gauri Shankar Gaur case. We discussed that in General Clauses Act. So you will be going back to the same legislation, 18 Companies Act 2013. Okay. So that's it from my side. Thank you, all of you. It was a pleasure, interacting with you on General Clauses Act. We will be talking about the other interpretation of statutes in our next session, that is on Monday, and two sessions on interpretation of statutes. So looking forward to uh, discuss with you on that. Okay. Any other questions you people are having? You are most welcome. Any question or any reflection you have, please feel free to give your reflection or question. I would request the administrator if they can allow the mic. Any one of you would like to give a reflection or any point you have to make, please feel free to do that. Kuldeep, it is an interesting question. Difference between a lawyer and an advocate. They are one and the same. Lawyer and advocate is interchangeably used, because nowadays we don't use any different term, because in the before the Advocates Act, 1961, we used to have different terms: munsif, lawyer, advocate, barrister. All these terms have now come into advocate. So it is the definition of advocate is given in the Bar Council, in the Advocates Act, and it is only one person who is registered, who clears a legal degree in the bar exam and is recognized as an advocate. So it is the recognized. Then thank you everyone. Have a nice evening. The remaining part of it. And have a nice weekend. See you on Monday then. Bye bye. Yes, good night. Thank you.